if I really, if you really go by what I'm saying is that in clause B and C, there will be an amount of tax payable. It could be stayed, it could be recoverable because there's an order passed, a definitive order where a demand has been created. But in clause A, it is proposed, it is not yet payable, right? So in that sense, amount of tax is strictly not payable under 128A clause A. Again, like I said, this will be an academic point. To implement the scheme, we'll have to really consider this as amount payable, even though it is stated in the notice. Now, if you look at clause A, it says it has to be payable pursuant to a notice under 73(1). So what does it not cover? And ADT2, which has been issued, will not be covered here. Okay. Basically, audit-related liabilities which have not yet reached the stage of 73(1) will not be covered here. Liabilities drawn up pursuant to an inspection or an enforcement proceeding will not be, which have not yet reached a stage of 73. Of course, 73 is somewhere all out expired, but which has not reached a particular stage, definitive stage, will not be covered here. Scrutiny related liabilities where you have already paid off or they are, if at all, pending for whatever reason, will not be covered here. So basically, the starting point of the scheme is a 73(1) notice, which is a must or a prerequisite for you to fall within this scheme.
Because I would just like to come in here, just interrupt for a second. I think why notice has been kept because notice for the year 17, 18, 19, 19, 20 under section 73, the last date of notice is already passed. So yes. I think that's why only the word notice is given, because even if an 82 is issued after this, notice under 73 cannot be issued. So I think that's why that is given.
Right, you're right. In fact, not notices. By the time the scheme is out, even the orders will be passed.
Yeah, orders are also passed for 17, 19, 20 maybe left.
It is just a couple of weeks left now. So possibly that's the reason they have rolled out the scheme only for the 3 years. This somewhere also reconcile related.
We have one more question. We have one more question from participant. Soumya ma'am is asking whether MOV 9 notices, sorry, 7 notices, they will also be covered here.
Okay. See, there is, for this we need to go back a step to understand whether MOV proceedings are also linked to a detailed 73 proceeding. Okay. Now, it's a subject by itself. To just give you a short answer, ma'am, in my view, it's is an MOV proceeding is only for release of the goods. It's not for fixing the liability or the penalty. Okay. The amount you pay is not towards a particular liability. That liability has to come either by way of pre-amendment, by way of a 73 plus penalty or a 74 plus penalty, and post penalty amendment. Possibly, I would believe under a 122 read with 127 as well is my take. But again, that's something which is practically not happening. But to answer your point, if the law as it stands today, MOV notices are not governed by 73 because it's only penalty which is payable. It's not tax short pay. The MOV penalties are not for tax non-payment. It is for basically not complying with section 68. So in that sense, 73 and MOV fall under different domain. Right.
Rishabh, one more question here. Like as you're saying MOV, because the amendment has happened in 2021. So prior to that, we were taking the color of tax and penalty for MOV proceedings. So can we just try to take a relief for those years, because the amendment of taxes has happened as penalty from 21. So that is one way to look into this aspect.
Ma'am, so for that, we need to first answer the question, does MOV have to necessarily be succeeded by a 73 or a 74?
Yes. See, actually, actually what is happening, so that is there. Because it is not under 73 and for 128A, the prime condition is that it has to be under 73 and tax, interest and penalty has to be payable. So in case of the MOV 7 notices that we have received, they include an element of tax, but not interest and penalty.
Yeah.
Yeah. So, Okay, so that is the way we are reading.
Yeah.
And the
Yeah.
second thing is, Rishabh, like,
And second, even there's another point in the scheme, which, sorry to interrupt.
Yeah, yeah, bully.
If he's not going to issue a 73, you cannot say the scheme is applicable to me because he ought to have issued under 73. Right?
okay,
Right.
It's a question of fact. Has he issued or no?
okay. So sometimes like the 74 will get converted to 73, like based
I'll
on
come
this
to that.
appellate order.
Ma'am, I'll
Yeah,
come
so
to that.
that way,
There's a
I think
slide
that
for
way
that.
you can touch there. Yeah.
Yeah, I'll come to that. I'm just trying to lay down the basic terminologies. Then we'll come to all those
Yeah.
FAQ kind of
Sure,
questions.
sure.
Right?
Over to you, Rishabh.
Yeah. Now, where was I? Yeah. When a notice has been issued. Now, the second thing is that it has to pertain to a period which is for the period July 17 to March 20. Okay. And the tax has to be as per the notice, statement, or an order. So here, the scheme is applicable qua the entire notice, statement, or an order for the tax period 17 to 20. Now, both this are in, of course, the period could be broken up in parts, but you cannot make the notice statement, bifurcate them, break it up into parts, and then claim the benefit of the scheme, is my understanding. The said person has to pay the full amount of tax payable as per the notice, statement, or an order. So you cannot bifurcate a particular notice statement into sub issues, or in fact, I can go to the extent of saying that you cannot bifurcate a notice or a statement into sub parts as well, or sub tax periods. You will have to be in or out of the entire notice. So let's take two cases where you have three notices for 17, 18, 18, 19, and 19, 20. You may choose for 17, 18, 19, 20. You may skip 18, 19. That's one scenario, which is okay. Okay. But you have one notice for 17, 18, 18, 19, 19, 20. Okay. I'll go to the 74 5-year processes later. I'm just on this. Let's say you have one notice for 17, 18, 18, 19, 19, 20. Okay. There are, let's say, 10 issues on this. My first principle reading goes that you need to go to the scheme for all 10 issues for all the 3 years. You cannot choose between 1 year or 2 years, even though the word says or a part thereof. Right? Because you have to pay the full amount of tax payable as per the notice, statement, or an order. I hope I was able to, give the differentiation in my mind when I read these two lines.
So, Rishabh,
Right?
here, I think Rishabh, here we put some members. So, what is the view of the House on this? That if I have a notice for 10 issues, can I actually go for 128 partial waivers? Like, can I go for only, I can only pay 17, 18 tax and then claim the relief of 17, 18 and say not go for the issues, the other 8 issues which are there. What is the view of the House on this? Okay, Ravandeep
So,
is saying that yeah.
Sorry,
Yes,
I
Ravandeep.
just want to add the word or a part thereof has to be, to my mind, read with the period, like 1st July to 31st March 20. So any period, either the entire period, July 17 to March 20, or say a quarter of July 17 to September 17, it's like that. So the part thereof is for the period of the notice and not the amounts within the notice. So if a notice is issued, then we have to look at it as a whole. It's to my mind, it's like that. If I have to read like that.
And one more thing, if you go you go further, then it is mentioned that the said person pays the full amount of tax payable as per the notice. So that also supports that you cannot pick one or two item or left the other 4 or 5 items.
Right. So whether we have the array of issues to choose from, or whether we have the array of even the periods, I would believe in a single notice, you don't have both. You have to take it entirely.
For some audit cases,
Yeah.
notices are issued for the year 2017-18 up to 2022 or so.
Correct.
So the
Correct.
period could be expanding
Correct.
more than that 31st March 2020 also.
Correct. I know. In fact, that's going to be I expect this to come by way of an FAQ, if you ask me. The scheme really doesn't permit it. This is the central style of working. And in fact, even I thought about it, that if you have a 5-year period and within that 5-year period, you have only 3 years, I'm sure this is going to go by way of a representation, and the government is going to roll out an FAQ saying that you pull out 3 years, but among the 3 years, you cannot pull out just 2 and choose one and not one. I think that's how it may come out. The law doesn't really support that.
I concur to Rishabh Bhai's view on this because I'm reading the sentence like this, that this particular point of that it may be for a part thereof is not a choice given to us. It is the department's choice that where they have issued the notice, and the notice may be pertaining to the 3 years period in
Correct.
toto or a part of the period. So
Correct.
it is not a choice to us that we will apply for the amnesty on any part of the year or part of the issues.
Correct.
This is my understanding
Correct.
of this point.
Correct.
And also,
Correct. I concur.
summary of DRC 01, it is on a cumulative basis. I think when these forms system will be there, it will go through summary of notice DRC 01, wherein cumulative figures are given.
Correct. Correct.
Right.
So I mean, I'm not, in fact, I had that point in my mind, whether this is going to be system driven or manual. My gut would be, it would be system driven. Whether they're going to be able to build the logic, or it could be hybrid possible, but they'll have to build this logic into their systems to waive off the penalties through the liability ledger. That's something I think we'll have to wait for the rules to really pan out. I'll just move a little bit ahead, and then all these questions we can also deliberate once I lay down the.
Yeah, Rishabh, just one question to Parth, which Soumya ma'am has asked, that can we pay for partially and go for amnesty? Sorry, go for appeal for part, rest of the part. So that will deal in the question and answer later.
I will deal with that. I will deal with that as well. So in fact, I also have a situation where department out of 10, department has dropped 5. You choose to appeal on 3 and you pay 2. Possible, what could be done in those scenarios also? I mean, we'll have all these situations tomorrow.
Yeah. Okay, let's move on.
Yeah. Now, look at clause B. This was something which was a little bit, interesting for me. It says an order has been passed and no order has been passed at an appellate level, right? Everything else remaining the same in this slide. Amount is payable. Adjudication order and no order and appeal. Now, what does it try to say? It does not put on the appeal should be filed and pending. Very, peculiar. It says an order has been passed, but no order 107. Now, does this implicitly state that an appeal ought to have been filed? If you go very threadbare, it says order passed and no order under 107. So, if a person has received the order, received the demand, let's say he has filed the appeal within 3 months or 3+1. Yes, an appeal is pending. He withdraws the appeal, or an appellate order is not yet passed. He falls within the scheme. No issues, no problem with that. But let's take certain sub scenarios. An order has been passed. Appeal time limit is over, 3 or 3+1. Of course, an order can never be passed under 107(11), right? Or an 108(1). Can you say he falls within the scheme? Now, if I have to look at it, both are not at the same pedestal. One is accepted the liability in that sense, and the other one is still contesting it. If somebody says, no, this is a dispute resolution, the dispute has to be pending, then we are going to face a kind of a resistance from the department. But look at it the other way. Even if an order has not been, even if an appeal is filed, you need to ultimately withdraw it. There are provisions at the later stage. So if somebody really does not file it, to ask him to file it, keep it pending and again withdraw it, does it make him different from a person who has not filed? Ultimately, both are, a tax which is payable as per the order. The emphasis here is that the tax is payable as per the order. It might not have been recovered from the taxpayer for whatever reason. Okay. Then you can. So somewhere if somebody wants to take a liberal view, he will say yes, even if the appeal is belated or appeal not filed even within the appeal prescribed period, or an appeal is filed and if it has been dismissed for want of time or for want of pre-deposit or for a particular defect, can all of them be placed in the same pedestal? Is what really came to my mind. See, nowhere the word dispute resolution has been used. So, and it does not say the appeal should be filed and pending, which was there in a lot of our state schemes and a lot of our appeal, income tax appellate dispute resolution schemes. It's peculiarly worded. It says no order has been passed. So here I see a kind of a duality in the view. We will face some, backlash on
So,
this.
Rishabh, can we go to the house? The views quickly. The members of the house can share their views
Yeah.
on this.
Sir,
What is
with
their
this
view?
regards, in this
Yeah.
regards, I just feel that if you go to C clause C, wherein it says that the appeal order is passed and the tribunal order is not yet passed.
Exactly.
So same logic, no tribunal is not yet formed.
Correct.
So for sure, no one can file in tribunal. Therefore,
Correct.
there cannot be any order. Same way, for an appeal also, if you have not filed also, still the scheme should be applicable.
Even I
I mean,
concur with your
of
view.
course, they're
My
not. B
view
and C is not at the same pedestal. There is an impossibility. There's a indefinite time limit still. But yeah, if you really want to promote the scheme and want to make it as large as possible, the government may be benevolent and say that fine, even if you miss the bus, you can come back and resolve your disputes. But the other side,
I think the intent here is that your order is passed, but your appellate order is not passed. So even in those cases, they will be covered. I think that would be the intent. And so, as you rightly said, that if there is a benevolence that they consider that any kind of dispute needs to be resolved, because the ultimate intent of 128A is to reduce the burden on the tribunal going forward and also the High Court. So if that is the intent, I think then they will go with this progressive kind of a view.
Possible.
But any other view in the house, from the house quickly, because we have another maybe short time.
Rishabh bhai, are you trying to say that was there any need of the clause B? Are you trying to say like this?
No, I'm not questioning the need of clause B. I'm only pondering over the second part where they have anchored upon the finality of that proceeding rather than it being pending.
Okay.
No, there could be a situation where they have gone on a writ instead of a first appeal.
Correct.
So in those cases, what happens?
See, possibly that can be factored. See, but I would not rate them at the same pedestal. Would you say a person who has paid order has been passed, not exercised his right of either remedy, equal to the person who has exercised either in the tribunal or in the High Court? Is the dispute still pending? That's the question I'm laying before this house.
Just to add to what Rishabh is saying, Arup sir, you mentioned that the objective of the scheme is to reduce the burden on tribunal. But if you look at the memorandum to the finance bill, it says it is a conditional waiver which is being offered. So that means they are seeing it as a benefit to the taxpayer and not a burden to be reduced on the taxpayer. Earlier schemes also always have come saying to reduce litigation. Those words have not been used here.
Correct.
No, here the word conditional waiver has been followed because for the first time in GST, they have gone by the principles which are followed in the state VAT. So that's if you see typically this question that, that if tax is payable only then the waiver is eligible. So this is coming out from the state VAT where only interest and penalty, they were not given the benefit. So that's why it's a conditional waiver subject to certain conditions being fulfilled. So that's why this particular thing has come here. But what you have said is right. The object and the intent has not been pronounced clearly in the memorandum.
And sir, what could be I think answer could lie within this line. Why this clause B and clause C are separately given? What could be the reason for that?
Clause B and clause C.
Yes, why these are separate clauses? There could be a case that order passed so and so, but no appeal under section 107, 10. They could club these clauses. What could be the purpose of drafting these clauses?
They have tried to cover all the scenarios that would be possible.
Exactly.
See, first scenario
that could be covered in a single clause. Why B and C will be having?
That's probably because they are pending at different forums.
Sir,
See,
B.
that's the problem because they are sending at different forums. You'll have to withdraw it from particular forums, and there's a particular process to withdraw it. So
Yeah, but
possibly that could be the reason.
Rishit bhai, according to my view, 10711 says that appellate authority can suo moto by way of their revision, they can go forward for other things. So it may be the scenario that 73 orders or 73 notices have been passed, where appeal order is also been concluded, but appellate authority have gone for the revision by way of 10711
Department appeal.
department
So, no,
appeal.
we have cases of even department appeal factored in this provision, and you have cases where an appeal has not been filed, but an revision has been taken up. So that's also factored in this scheme.
Yes, yes.
Okay, I'll just
In
move
all the
ahead.
countries,
because of
all
some-
the penal.
I'll just move ahead a little bit.
Yeah,
Now
yeah,
look
yeah,
at clause
yeah.
C. Look at clause C. It says an order has been passed under 10711 or a 108.1 and no order has been passed finality. Okay, now look at this. Now, if you see...
Sorry to interject, your screen is not changing.
Screen one.
No, it's changing. It's only the clause which is changing. So that's why.
Yeah, see is there now. Yeah. Yeah, it is.
Now look at this. Generally, both 73 and 74 will culminate into a 10711 order, actually, if you ask me strictly. You don't have appellate orders separately for suppression and non-suppression cases. So there is a kind of devil's thought which comes in here. Can you squeeze in suppression cases where first appeal orders are passed under clause C? But I would believe that's really going head-on collision with the intent. And even the title of the section, title of the section is a waiver for non-suppression 73 proceedings. But, it's an interesting thought that 73 also will culminate into an order under 10711 and no order has been passed under 113.1, which is a tribunal order. Again, this is more an academic point. I would really not give too much of a legal weightage. It's just a point for us to really, in case we are pushed to the wall, to take it, right? Now, let's look at the exclusions of the provisos to this scheme. The first proviso says that if a notice has been issued under subsection 1 and subsequently an appellate authority says that, I think some background. Can I proceed? Yeah. Okay.
Arup, can you mute others?
I've muted.
Yeah. You can proceed.
It says that if a notice has been issued under the suppression or a fraud case, now you will have cases where, let's say, 5-year notice has been issued by the central tax guys. And subsequently, the appellate authority says that that notice has to be, issued, has to be treated as a notice under 73. Now, look at this, okay? You will have many variants here. You will have 5-year notices issued way before December 23 also, September 23, let's say, okay? You will have it issued even after September 23, and even if the tribunal says, or the appellate authority, not tribunal, I'm sorry, says that, okay, it's benevolent enough and says that, okay, this is not a suppression case, it's a scrutiny matter, so it should have been a 73, then 1 year gets dropped, 4 years will continue. Similarly, you will have other variants subsequently up to April and up to August, etc. I'll not get into too much depth, but I'm just giving you the food for thought. The proviso says that once it is held, it's to be treated as a 73 notice, then the benefit of the scheme is available. If you ask me this, according to me, and I need the views of the group here, according to me, this first proviso is academic because 75(2) itself says it. It deems it to be a notice under 73. I don't know what extra this proviso is really doing. Okay. Just hold on, but I'll add some more, variants to this. So do we have to really, wait for the tribunal or the appellate authority under this proviso? Yes, you'll have to wait. You'll have to wait a conclusive order much before the notified date. And only then this proviso will operate. Until then, the implied meaning is that whatever notice has been issued under 74, even if you want to challenge it, saying that it's not a fraud case, until a definitive order is passed by the appellate authority or the tribunal, you cannot enter the scheme. So somewhere you are at the mercy of the adjudicating authority for a notice to be issued under 73, or you're at the mercy of the appellate authority for them to say, yes, this is a 73 proceeding and not a 74 proceeding. You cannot claim it by way of, a legal precedent or a circular. I doubt that. It has to be a statement, or it's a fact that it has to be issued under 74 and then struck down to be a notice under 73. Look at another, but the proviso as such, I don't know if it adds really any mileage to 75. It really says the same thing. But look at another fact. Let's say you have had a 3-year notice under 73(4), and there's a follow-on statement which necessarily will be treated as a 73. It will not be treated as a 74, because section 74 says a follow-on statement is, even though it will be a fraud case for the first 3 years, subsequent years it will be deemed to be a 73 proceeding. So look at the curious thing which happens here. The follow-on period may strictly get covered under the scheme by way of 128A, 1B or C, whatever the clause may be. But the primary period will not be covered, right? So whether, you really can go ahead and claim this benefit, I believe, yes, you can. Again, like I said, the section under which the notice is issued is only going to give you the license or the permission to enter the scheme. And 74, by its deeming fiction, treats this as a notice under 73, even though the previous periods were alleged as being a fraud or a suppression case. So both these variants, I believe, can fall under the scheme. Now, anybody who would want to just add into this?
Yeah.
Anybody wants to add?
Rishabh bhai, I just want to confirm one thing, that as far as I understand, there is no date provided as on date as to what will be the applicability of the scheme vis-a-vis that
Exactly.
the appeal should be pending or open on this date.
Exactly.
Right.
You're right.
And
Yeah.
maybe the last date to make the payment is, what I'm hearing is 31st of March 25.
Correct.
But they have not notified or mentioned the date
Correct.
on which date it should be pending.
Yeah,
This
it
can
doesn't
be a
give you
very
the
crucial
status. It
point.
doesn't freeze a date saying that you check the status as on a particular date. You're right. Absolutely right. This is how the wording, it says he pays the full amount of tax on or before the date. It does not say when do you check the status of clause A, B, or C. But somewhere, if you have to really implement the scheme, it's from the date it's legislated up to the date you make the payment and make the requisite filings under.
So why I raise this point, because let us say tomorrow that view comes that it has to be appeal should have been filed or something should be in pending, like what we discussed for point B and C, right? Like what you mentioned, that you should have filed an appeal. So maybe if there is no date mentioned, then what we can do is we can now prefer an appeal even though if it is time barred. So at least we will fall in the scheme and will make the payment before the appeal is rejected.
You can, and it may get dismissed for time limit, which is okay.
Yeah, but before it gets dismissed, see, I have to make the payment before 31st of March 25. And what we just discussed, there is no time mentioned about when your appeal should be open or when it should be pending for getting qualified in this scheme. So let us say my case is now time barred, which we were discussing, and we have not preferred an appeal. So maybe now I'll prefer an appeal, and before it gets rejected, I may just fill in the form and take the benefit.
But in those cases, Vishalji, the appeals are almost rejected within 7 to 10 days. They issue a so-called notice that why it is time barred, why should we accept the thing, and then they reject it. They don't issue appeals directly in that.
Correct.
So
But that's what I'm saying. If we want to get ourselves covered, if we have that much window of 7 days also, I think that should be sufficient. We'll file the appeal and immediately we'll fill in the form, whatever it comes for this. Why I raise this, because I'm presuming that there is no such power given in the section that tomorrow they can notify a date that there will be this scheme will be applicable only if your appeal was pending on a particular date. I believe there is no such power embedded that they can tomorrow, by way of rules or some notification, notify a date.
In fact, the prescription is only, I read the entire section. Reference to the rule is only in one particular case. I'll just tell you. It says.
I think it is regarding the procedure.
Only,
how you
only in the clause 1, which says shall be deemed to be concluded subject to such conditions as may be prescribed. That's the only prescription for rule.
Correct. So it may be for the procedure, how you will withdraw the appeal.
Procedure to withdraw. Actually, that will be the main orientation there.
Also, one thing I think you may just deliberate upon, if time permits, that the word uses taxes payable. Now, in many cases, during audits or during DRC 1A, we have paid the tax, but the
Correct.
matter is pending for only interest and penalty. So, whether
Correct.
those cases can be covered for this MNST?
In my view, it may not be covered. Yeah. In my view.
So that is the main moot question of discussion here.
Yeah.
That what would happen in all the scenarios wherein, say, show cause notice was issued for tax, interest, and penalty, and during the proceedings I have paid the taxes, but I have not paid the interest and penalty and gone into
Now,
an appeal.
the question is paid it under protest. If you paid it under protest, yes, you can still say that it is still payable subject to a particular appropriation. Okay. Although people are saying that there's no concept of protest, I differ from that. But if you really lodged your protest, then yes, I believe you can take that stand and say that it's subject to appropriation by the tax officers. In fact, I have a particular slide on that. I'll come to that. I'll just answer this when I reach that slide. I'll just go down to the because of provided for the
Sorry, on that Vishalji's point that in case appeal appeal has not been filed and it is time barred, so to get into the scheme we file an appeal and in that 7 days we make the payment to avail the benefit of this 128A. To my mind, if we conclude that there is no such bar under that clause B, that appeal has not been filed and the proceedings have got concluded, it's time barred. If we say that such orders are in the scheme, then we may not even have to file an appeal and we can just go ahead and take the benefit of the scheme. If we read it in that way, I'm saying.
Yeah, so I think that's wondering, should we, keep in, for somebody to really raise this point. Vishalji's point is more like, midway path, saying that let's file it, let's get it dismissed either on time bar or on defect, etc. Then you have a stronger case to clear the scheme. I think that's what Vishal Bhai's point is, which I really concur. That you have a stronger.
Rishabh sir, this is what Vishalji is saying is that means we are making an assumption that if an order has been passed under Section 73 and appeal has not been filed, time has gone away, then we are not eligible for the scheme. But I'll rather say that is covered.
No,
to my reading, it is covered. So
No, sir,
even if it is not covered,
I
then
agree it is
then we
covered.
wish
I'm
to
just
file
giving
for
a
it.
way out in case that
Correct.
comes up as an issue.
Correct. To
No,
allay
that is
that fear,
covered. It
he's
is
giving us
still
a
tax
practical
payable. It is even
viewpoint.
if it has gone to recovery, it is still tax payable.
Yeah,
What
I mean, even in
Amitji was
situation
saying.
where there may be a situation the matter is pending in court. In that case, why would you file an appeal again?
Whatever may be the situation, if the tax is payable, then you are covered under this scheme.
Yes.
Sir, actually, what we are, preempting as an apprehension, as a point is the second part of this clause, okay, which is what the department could very well say that the second part of the clause becomes redundant if you interpret the law in such a way that an appeal need not be filed. Okay, that's what the department will certainly take as a stand, right? Now, then to solve this litigation, you're going to enter another litigation. So what Vishal's point is that to strengthen your hands, you file an appeal, get it dismissed. There we are giving effect to this entire clause and yet making ourselves eligible. Right, Vishal Bhai, this is what we are trying to really, address.
Yeah, I'm just proposing a way out in case
Correct.
that is the view. Though I'm not concurring to that view, I still believe
Correct.
all these cases are covered, despite of being time barred or being in writ. Obviously, they have to be covered, but just to be extra protective.
Correct. Which it's a possible interpretation which the department can take. They will say that you're making the second part of the clause redundant. And in some sense, if you really extend this clause for non-appeal cases, it becomes redundant because when you say no order has been passed, it implies that it is due to be passed or it is about to be passed or it is in the process of being passed.
Right? I'd like to differ here. I think the purpose of B is that we have got an order from the adjudicating authority, but the order of appeal that has not been received finality. We We have not got an order in appeal or the order by the revisionary authority. They have not passed an order. So we are in that stage. So after the order, maybe we have filed an appeal or filed a writ, or we have not filed. But ultimately, the appellate order or the revisionary order that has not been passed. That is
I'm playing devil's advocate here. I'm saying somebody is
Yeah,
going to say
that's
it is
I'll
due to
agree
be
with
passed.
Arup there.
See, when you
Hello.
go by, the issue which will come is somebody is going to interpret this by saying that, okay, no order has been passed, implies that, okay, as on a particular date, it's not passed. If not for this scheme, it would have been passed at a future date.
Right.
So therefore, the dispute is still live. It is only for them this clause is applicable, is somebody who can really take that view. I'm giving that
Hello.
possibility. You cannot rule out that view. It's a
Yes, sir.
different thing that we may ride upon the intention to solve disputes and pending an amount which is tax payable. But if you have to really give impact to that entire word, where any amount of tax is payable by a person chargeable to tax in accordance with an order which is passed, and where no order has been passed under 107.11 and 108.1. So it's a question of time. That's what we need to really give emphasis on, even on the second portion.
Rishabh
I
ji,
think Rishabh ji, I think Rajiv ji wants to come in. Yeah. Rajiv ji, boliye.
sorry, Rishabh ji, there is no such word that no appeal has been filed. No order has been passed. Now, if you take clause B to C, this is a chronology. Please change slide 3 and 4. If you see slide number 3, then slide number 4.
Yeah.
It looks like that now an order has been passed under so and so, but no order, tax is payable by notice, and no order has been passed under appeal.
Yeah.
It looks like that it says that appeal is filed and order is not passed. Now, clause C, order is passed by the first appellate authority, but no order has been passed by the tribunal. It looks like that, which we were saying, why B and C are separate. It looks like that appeal should have been filed.
Right, Rajiv ji,
It
I
is
agree
not
with
like
you.
That's
It
so
is only
Rajiv sir, that's
first stage
exactly
is
what
only
we are
where
laying before this house here, that both interpretations are possible.
Yeah.
But are we in a stage when we are in the frame of mind to solve a dispute, really keen on going and adding some dispute to it, or trying to find what Vishal Bhai is saying, a midway path?
No, yes, that is why Vishal's point holds ground.
Yes.
That it must be given a thought. This appeal should be filed.
Yeah, yeah. I mean,
For
because
that purpose, yeah.
if we really want to really resolve the dispute, then let's file it for whatever
Yes,
it's worth,
yes.
and then let it meet its fate. And then we can really claim to be saying that, then nobody can say that an order has not been passed or an appeal has not been filed.
Yes,
I'll just proceed a little further because I'm just short of time and I have not crossed half my slides. Right. The second proviso, now here again, here
Rishabh, sorry, I want you to logically conclude at one point and stop because 9:58 already.
Yeah, so I'll conclude.
And we'll continue next.
Yeah, we'll continue in the next Saturday. Yeah.
Yeah, fine. I'll conclude the second proviso and subclause 2, 3, and 4, and the rest FAQs which I have, I'll take it up later. Okay.
Right.
Now, this is a thought which I'm going to leave with, and I'm going to give my thoughts yet. Is it says the conclusion of proceedings under this section, the proceedings in respect of this notice are concluded. Okay. And this is where fundamentally I'll go back to the point of whether this is an amnesty or a dispute resolution or a waiver scheme is where, and really, I would really want us to ponder over. In my view, it's not an amnesty scheme, right? We need to rule that out of this contention. You're not going to get an immunity for the entire period. You are only going to get a closure of a particular proceeding. So it's not an amnesty. Is it a dispute resolution? If you read this clause proviso, I may believe it's still not a dispute resolution. I'll tell you why. Because you are not going to close this dispute forever. It can still get opened up by way of a subsequent proceeding. Okay. Is it a waiver scheme? Yes, I believe it's only a waiver scheme. So in some sense, I really concur with what I was having a discussion yesterday is that it stops short of being a dispute resolution scheme. It's more a color of a waiver scheme. Now look at this proviso. It says the conclusion of this proceeding under this subsection in cases where an application is filed under 107(3), that's a department appeal, okay, or a 1112(3), which is again a department appeal before the tribunal, okay, or an appeal has been filed under 117, that's a High Court or a Supreme Court, 118 department, or a proceeding has been issued under the revisionary powers against an order under clause B or C, or against the direction of an appellate tribunal, etc. So this conclusion, which they have referred to in clause 1, okay, is subject to these scenarios where an appeal could be filed by the department or by the first appeal, against a first appeal order, or against a second appeal order, or before the High Court, Supreme Court, or a revision could be initiated. It shall be subject to the condition that the said person pays the additional amount of tax payable in accordance with that order of the appellate authority, tribunal, or revisional authority within 3 months from the said date of the said order. Now, this is a little complicated proviso, but what I could really take away, I'll just put down. Let's say you have 10 issues, 3 in your favor, 7 not in your favor. Order has been passed. You're in appeal before the tribunal, before the appellate authority for 3 of the issues. You, of course, for the 7 issues, sorry, for 3 issues, you'll not, there is no payable, the tax is not payable. For the 7 issues, the tax is payable. You apply for the scheme, you pay the tax, interest, penalty gets waived. Fine. Okay. Can department open the 3 issues? Yes, it can open the 3 issues, either by way of an appeal or by way of a revision. Let's say it gets confirmed against you. This could happen before the scheme or after the scheme, right? It doesn't really stick itself to the window. And that's where I go back, it's part of the enactment also. If this additional tax is payable, the conclusion of the proceeding under clause 1 is subject to the fact that you pay the additional 3 tax within 3 months of the said order. So if those 3 issues which were in your favor historically, an order has been passed in your favor, department goes on appeal, or a revision proceeding has been initiated against any of those 3 issues, and a tax becomes payable, okay, that additional tax should be paid within 3 months of the said date of the order for the conclusion of the proceeding, which was prescribed under 128(1) to be continued to be applicable to you. This is a dangerous provision in my view, and this is how I could understand this complicated provision. It does not give a time frame that this appeal has been filed before the notified date or after the notified date. That's point 1. 2, look at how the wordings are. If you ask me, there are 2 benefits in 128A. It's not 1. The benefit is no interest and penalty is payable. And that's where the second benefit comes. All proceedings in respect of the notice are deemed to be concluded. Right? There are 2 distinct benefits in this second part of 128A1. What this overturns is only the second benefit. That is, the conclusion of the proceeding is subject to. So your interest and penalty waiver for the 7 issues continues because that's not overridden by this proviso. The only issue which then opens up or reopens because of this department appeal on the 3 issues is the proceedings will not be now held to be concluded, is what I could take away from this proviso. Okay. Again, I'll repeat. 128A talks about 2 benefits. I'll just conclude this for now.
Yeah.
It talks about interest and penal waiver and all proceedings in respect of the notice order statement, that is out of all the proceedings in respect of the 10 matters deemed to be concluded. But the proviso says, as regards the conclusive part of the benefit which was there under 128(1), is subject to a condition that a department does not file an appeal or to the respective forums or a revision has not been issued. If it still files an appeal and there is an additional amount of tax payable, you ought to have paid that additional tax within 3 months of the said order, basically when it reaches its finality. Now, whether it's again subject to further appeal, etc., is something which we need to really look at in the next session. But I want to leave this with everybody with this word of caution that it's not an amnesty scheme. This second proviso gives me an interpretation that it's not even a dispute resolution scheme. In fact, it's merely like a late fee waiver scheme, if you ask me, with department not being, it's not going to be, it's with its hands tied. If it has to reopen some other issue for that particular tax period under 74, or reopen the same order for the favorable part for which taxes have been dropped, I think it's still open. So that's why I would say it's somewhere stopped short of a dispute resolution scheme as well.
Thank you, Rishabh ji. I think that's the homework that we are taking after the class work. all of us are going to delve on this, and the next Saturday we start on this proviso where we're going to discuss about this, and also the FAQs that we have with you. So before we conclude, may I request the CA Hanish S. Hanish ji, are you there to offer a vote of thanks?
Yeah, I'm there.
Yeah, if you can offer a vote of thanks to our learned speaker today.
Hi, Rishabh. It's always a pleasure listening to Rishabh. And 128 is a very complicated topic. I think more we are reading, more we are getting complications. Thank you very much for making it simple, Rishabh, and looking forward to your second session.
Thank you, everyone. Thank you.
Thanks to all the participants. And now I would like to go to Venu for his final word before concluding. Venu, over to you, Venu.
Thank you. And as Arup said that we will have a homework. There has been a lot of different interpretations. I would urge members to mull over the various points which Rishabh ji has brought in. And in the next session, before we start with the FAQs, we can counter each other views and get in detail. And thank you, Rishabh, for bringing the points in front for the discussion. Thank you.
Thank you, everyone. Thank you.
Thank you, everyone. Have a wonderful weekend ahead. Looking forward to meeting all of you on next Saturday. Thank you very much.